yeux de lumière qui voient passer au loin les oiseaux.
Well, it's easy to just to get over it and say, no, it's not really relevant. Having said this, things like this are kind of interesting for legal thinking, for getting some ideas of how far legal thinking reaches into daily life, and at the same time to see how far really small incidences, how meaningful they are for an entirety of social, societal issues, as well actually on human rights issues, if you want, when it comes to looking at small incidences like coming late to class, coming 10 minutes late to class, looking then from there at societal development, at development, and at human rights issues. Now, I'd like you to take it seriously. At the same time, don't take it too seriously. There are so many different things involved that you can take it either way. Now, I don't know actually if we talked about a specific time. Class begins at a specific time, sharp, as we say, or if we didn't. But we are now quite a long time into the year, and there had been something built up as this is the time we start class, meaning at 2:20. No, actually 2:30. So we talked about it, or we didn't talk about it. It is what is called actually custom, law or practice. Custom and practice is or has actually a legal status that we can say if we as class, we as society, a shop or a political regime acted according to a certain rule, this became custom and practice. This became, in its own respect, a law, and we can rely on it. We can refer to it. We can say, this is how it is. This is how it is defined by law, even if it is not written down in a statute book or in a legal act or whatsoever. It is relevant as a matter of law, as a matter of validity of a reference. And we always can say, having this case, there is a good reason that we can refer to it, because there is always somebody, a minority or a majority, that refers to this time and says, okay, I will be there at 2:30. Now, what can you do? You can say, okay, 2:30 is the time, we start at 2:30 and we take it from there. If there is everybody there or not, it doesn't really matter. This is the time we set. Or you can say, but hang on, there are 2 people, 4 people, there is half of the group missing at this time. And even if we said we start at 2:30, we said it or we did not say it in explicit terms, but it is valid over the 10 times, over the 15 times we got used to it. This is the custom and practice. There are these people, they are missing out, and they have, of course, a right as well to be educated. No, they have this right, and this is a right that is written down. They actually signed a contract. We, with custom and practice, we did not sign a contract on the specific time. So you have, again, the struggle of law, and you have a conflict between two legislative powers. The one is custom and practice, the other is the law as it is written down. What to do? Wait for the others, meaning you waste your time while you are waiting. I waste my time because I had been on time, and we cannot do really freely avail of this time. We depend on this situation that we are waiting, actually. This gives our time a specific framework. And whatever we do, it is not the free use of time. Now we, the group that is already earlier there, meaning on time, we can do something class-related, meaning those who did not come on time miss out. Or we simply can wait, then it's completely lost. Even if we do something that is useful, but it is lost in terms of the free appropriation of time. So, the one thing is we can do what is written on paper, or that is, or has a legal status qua custom and practice. Or we can say, we look for other criteria and say, what is just in this situation? What is the right thing to do? And then it opens up really a whole field of different options to assess this situation. We can say, depending on the situation, okay, these are really strong people in the group, and in a way we depend on them, meaning they help us to shape the class, to have an active discussion on it. Or, if it is not this case, we can face the situation that we say, listen, these are the weak people, and they really need additional hours, they need the time to be able to discuss things, to develop things in class. Those who are strong, they can do it on their own, they can work at home, but those who are weak, they need the support of the class. Now this is something we have to sort out, going on now, formally or informally. Now really being nearly at the end of the year, it doesn't make much sense, but we could say, if it's in the middle of the year or earlier, at an earlier stage, we can say, okay, we have to find a rule, formally or informally, we have to decide now what is happening in the future. What is the relevant thing, and how do we deal with it? We can say we deal with it by formally setting the time, and then we can go on and say formally setting the time is the one thing, but we go even a step further and say if you come late by 5 minutes, by 10 minutes, you get a certain amount of penalty points. Formally we can rule it, we can draw up a contract with the group, or we can actually look up the statute book of the university, which may say something on this. I know that in some, or in the one of the universities I worked before, I worked earlier in China, it said something, if I, as lecturer, if I am late, Actually, there was a certain deduction of the income if I would come late 5 minutes or 10 minutes. It was very strict. I never came into the situation that it was applied or it had to be applied, but at least the rule was set in a very definite way. Now, this is the one side of it. We have to find a solution. For us, we have to find a solution within the framework of the university, morally justified by law, or we have to find another way again, or not another way, but another perspective. So custom and practice is something, if you want, amongst ourselves. Then we have the wider field, and of course it is something as well where you would have the standard of a university or the standard of academia in a certain country. I remember one of my first questions when I studied was, what does it mean, actually, if it says 1400 to 2 o'clock CT? The other thing was ST. It's many years back. And CT, 1400 CT, 2 o'clock CT, actually meant 2 o'clock cum tempore, with time, meaning allowing for a delay. And it was kind of ridiculous because cum tempore meant basically you start at 2:15, a quarter past whatever the time says. So instead of writing immediately 14:15 ST, sine tempore, without time, sharp, you wrote CT and allowed for these 15 minutes. I thought it was ridiculous, especially because it was really 15 minutes. Now, this is the custom of the country, the custom of the academic world in this country. And of course, it is relevant that this is in the academic world. Later, if you go working in a bank, in a law office, in the government, there are different rules there. Again, you have them formally or informally set down. Now, but there is another thing, both when it comes to work or when it comes to education. What we offer is a public service. Who pays for it? It is the public, meaning in which way ever, what it means in concrete terms is a different question. We don't have to discuss it, but there is a public budget, meaning the citizenry of the country, in this case China, pays the university to provide education. Part of the provision of education is to do it from 1430 up to 1720, up to 20 past 5. And there is a break included. This is part of the rule. Now, what does it mean in concrete terms? Do I start lecturing sharp at 14:30? Or is it the door is open to move into the classroom, start all this equipment, which takes some time as well, Does it mean I open with giving the floor to you and say, are there any questions to last time? Is there anything you think we should discuss today? What is exactly meant by setting a framework, a time for this? Is it something where I say, today we want to talk about this and that text, now you have half an hour to read the text? Or is it about, now we start talking about the text because I asked you to read it at home? It is money, it is resources, public resources we spend, we use, and we have to do it in a responsible way, in an appropriate way, that we can actually say, in legal terms or in moral terms or in both terms, here, public, this is what we did, and I think this is the right thing, that we did it this way. This is, of course, hugely relevant in terms of what can be expected. And it is relevant as well, and again, in terms of the background, the criteria for this decision. Is it a moral decision? Is it a professional decision that I say, working such a long time strictly listening to me is too much, so we start with reading? And is it as well a decision that I say, well, most likely at least some will not read the text at home, so I provide the time here? Or what is the criteria? I can say as well, but you obliged yourself, committed yourself to attend this course, and this meant you work here, but as well at home preparing things. What can the public, the citizenry, expect, and what can the government expect? Because, of course, they are not identical. Who, again, sets the rules there? And what you have to see in this context is the level of education in a country, within a country. Of course, there are different ways of looking at it. You can say, look at this country that has such a high-level elitist education where you have some excelling universities, and this is what we actually wanted. We wanted to have an elitist education system where we have, 5% of the population going to these institutions, and that's all we are interested in. This, of course, is a different way of spending resources and a different approach of assessing educational system, compared with another one where we say education for everybody, education for all. And look at the development that you have had in China over the last years, over the last decades, where you have had only, for different reasons, a small group of people being able to avail of education in the extremely elitist system of Confucianism, of the Confucian schools, where only a small number of bureaucrats had been educated to maintain the system, to an education really for a huge amount of people, that you can criticize actually both approaches, that you say this closed system of an elite as education is extremely difficult to justify. Or you can say as well, if everybody gets education, everybody gets access to this high-level education, third-level education, what is the point actually? Can we maintain the quality of education if it is becoming mass education? It was actually something, I think, about 2 years ago, we have had a conference in Shanghai discussing this with opinions as well from different countries. And there was a variety of people from the different countries saying basically, we have very good experience with mass education, or we have very good experience with elitist orientation. Different countries, different people having different approaches, different opinions there. It's something, again, you can say it's not a struggle in law, but it is a struggle for law in terms of we have to get criteria in law, what is the foundation of this decision. How do we get this? Law is something where we say we want to have a formal framework, as we said earlier, a binary system, more or less a binary system, where we say it is true, it is not true, it is the truth of the decision. We do not discuss anymore. We only want to have a decision between yes and no. Yes, it is just. No, it is not just. Now, a little bit, I wouldn't say modern arts, but a little bit of arts. Perhaps you can imagine what this is. Perhaps you can put a name on it. It is the beginning of la justice, the misjustice. Mind, it is a female, it is a woman. La justice, the justice. It is always captured as a woman, and you can, of course, interpret this again in a wider sense, that you have the female values standing for justice, standing for soft approaches in terms of judgment, looking for justice, looking for the interests of the various sides involved. And then you have within feminism different approaches there that some people say, women feminists say, there is no such thing as explicit female values, or others would say exactly this is the point, get more female, get more women into government position, into leading positions, and then you will have a change of values of these systems, of government, of large enterprises or whatever. Leaving this aside, you have this, I know it's not really arts, but she's blindfolded. She cannot see. She does not see who is standing in front of her. In this way, she is neutral. And she just knows the facts that are carried to her, and they are carried in the same way to her, that she does not see this is ugly, this is not ugly, this is a very sympathetic, aggressive, whatsoever looking person, or I don't see actually the wider circumstances. I just see what is relevant. And what is relevant for this, to discuss it, I have something here in my hand, and this is a scale. This is meant to be a scale, and I distribute the things I get, the information I get on the different sides of the scale. And then I would see with the time one side or the other is going down, is getting higher. And this means one argument prevails over the other, is more important in terms of then, of course, depending on the legal system, depending on the customs and practice, depending on what is written down in the law, and depending on precedences, different things there. Depending as well on expectations, what is legitimate. So you would have a moral element there. You would have to include all this into your decision making. Now, what happens at the end of the day? You have the situation that actually it may be looking like this. So the left, well, depending on from where you're looking, the yellow is in a situation where you can say, okay, this is the winning case, this is the winning party in this legal case. Great. So there we are, and there we have justice. And then nothing happens, because there's something very important missing. And we talked again and again about it, not explicitly or not in this focused way, but what is actually missing? It is the sword, it is the power to actually bring the decision, bring the result into practice. That we can say this is relevant, not only in theory, not only in our moral assessment, but this is relevant as a decision with consequence A, B, C, D. And basically A, B, C, D means only binary code, yes or no, this is correct, this is not correct, this is true, this is just or not. You cannot be a little bit deaf, and you cannot be a little bit right. Something is just or it's not just. This is at least the understanding of especially positive law. And then we have this point we had been talking about frequently. Is it once or forever and forever, or is it depending on the situation? Should I, tense imperative, should I say this is the valid assessment for all the times, for all the cases in the situation, or is it something where, for instance, under the condition that there is this famous man with the axe standing in front of the door, that under this condition, actually the situation looks different than it looks in another setting. There had been in Ireland no schools for a long time, or no proper schools. It was a time when the British occupied the country, and there had been no Irish schools. So the Irish teachers, the Irish system, organized their own teaching in so-called hedge schools, meaning they were meeting in hedges along the roadside, hiding there and educating the children, educating as well adults, because officially it was not allowed. Of course, under this condition, under such condition, you have a different setting. For instance, when it comes to timekeeping, then you would have in a classroom everything properly ordered and a huge enterprise, if you want, where you have to coordinate teaching between different classes and it is important in this respect, and of course, then you have as well a different power ordering this and putting it in place, defining what it is about, where the power is, what the consequences are. Now we come to another point. I have Miss Justice there, Justitia. There you have the old form of the old female form, Justitia. And you have there now the question, can actually everybody go to Miss Justitia and say, listen, I think this is not right. I think this is not just. And I want you to decide if I am right or the other person, the other group is right. And then we come to the question, can really everybody go to Miss Justitia and say, listen, there is a problem, we have to solve this, and as we cannot solve it amongst ourselves informally, we ask you to solve it. You all know that there are different courts, different levels of courts on the local level, on the municipal level, on the regional level, on the national level, and then you have the same pattern in different countries. And you have a sometimes very complicated system. This is especially relevant for us, international human rights law. You have international bodies, I'll just leave it with this one here, that are actually interfering or deciding on the different national states. Now here is only two. You have about 160 members of the United Nations, and these would be courts, these would be institutions deciding or standing over all of them. You would have, just to make you aware of it, you would have possibly here something on the lower level as well. Within a country, you may have a decision between different municipalities or something like this. It can be a very complicated system. It depends as well, or it is then a matter as well, what kind of competence do the different courts or institutions have. And of course, and this is where it's relevant really, you cannot say, okay, there is a problem, I have a problem that I define as a legal problem, or we define as a legal problem, and we just go to a court. I should add, you may have international that are just linking the two or more countries, and you would have global institutions that are really kind of independent in their position. Anyway, the one option would be just go somewhere and ask for a decision, ask for a judgment. The other is you have a hierarchical system, or you have a system, and I talked about it occasionally in different contexts. You have procedural law. meaning it is defined by the law itself who can go where, under which conditions. Meaning you cannot simply go and say, actually I don't like this judge, I know most likely he or she is there, I go to this court. Or you cannot say, well, these are small little courts, they are not really relevant, I go to the highest level, because this is more important when they decide. This is the one thing. Who to whom can you refer? Where can you go? To which kind of court? This depends, on the one hand, on the level of the decision, but it depends as well that some courts are only on the regional level or on the federal level, central level. You would not have a constitutional court on the municipal level. That's only on the central level. You would have, of course, not even kind of courts on the municipal level deciding on bylaws. This is the one thing which court is relevant, but the other thing is, as well, can everybody go there and say, this is what I think, what I feel? Then it is getting relevant that there are different ways, different accessibilities, that not every court is accessible for everybody. So sometimes you need an organization that actually takes up your case and says this is really relevant for a majority of people, and we need a decision, a broad decision, not on this individual case, but we take this individual case that stands for many others. This is one thing. Then in other cases, you can go as individual and claim, please court, decide on this. And then you would have other cases where at least one or two parties, all parties, have to get a solicitor, a professional, who is able to make your case. Because usually you are not able to make your case, not even if you are yourself trained lawyer, possibly even less, because then you make only your case, you do not consider the different sides. It's again different. Sometimes everybody needs a solicitor, sometimes not. Now you can say, but this is interesting. If I don't have the money, what can I do? Basically, I don't go to court because I cannot afford it. Yes, usually there is, however, another rule, another procedural law that says actually if you cannot afford your own solicitor, your own instance, you will get support, you will get actually a solicitor that takes up your case. It is paid for basically by the state. It is interesting then to look at as well at the income of solicitors, of staff working in this juridical system. In principle, no, not in reality, but in principle, it is part of the definition of a professional that they do not get paid for the performance in terms of if they are doing well, they get a huge amount of money. If not, they just get a minimum. Remember the film on Kikero? Basically, it meant if the solicitor fails to win the case, he is sentenced to death as well. The rule says, in principle, you get paid for a certain value. Every case is defined by a certain monetary value, and you stealing a car or the theft of a car has a value of, I don't know these values, let's say 10,000 yuan, and setting a fire, setting a building under fire is 1 million. A divorce, depending on the wealth of the people, has another value than beating or abusing a child. So basically, you should not be interested in, I do this case better because I get more money for it. But basically, it should be this way. I get money, I get paid in whichever way. So if if I'm obliged to take on board this client because she doesn't have money herself, it doesn't matter, because I would get the same money from this person as I get from the private client who comes there and says, how much do you want? It is a very complicated system at the end, how to define the value of the individual cases, or of the not the individual cases, but the cases of a certain order, of a certain type. So you see that, of course, coming back to this little story of being late, you can say, actually, my human right for education is under pressure, is not respected because Peter did not start on time and did not fulfill his obligation to the state with the state's obligation to guarantee education. I, as a parent, or I, as a student old enough, age always plays a role as well, I go to the court and claim compensation. All those latecomers say, this situation had been completely out of control. I could not come in time. So I missed class, part of the class, and I had not been getting my right, the right for education. And society can say, in one way or another, you construct, if you want the case, this is a way of dealing with resources, public resources, with my money, the money I spent, I contributed to the state. This is an inappropriate way of spending the money because I don't feel my interest respected. She doesn't see who you are. She doesn't see if you are a good student or a bad student, if you are rich parents or not. She only gets the information. And this is where you have the solicitors and the barristers and all the different groups there, making the case and saying, okay, this is the information you have up to now, but I think this is relevant as well, and you should get this information as well to have a proper judgment at the end. Which does not mean I overcome the blindfolding, but it means actually on the opposite, I guarantee that you get all facts that are involved and that you can come to a decision And after coming to the decision, basically as well, you, the legal system, Justitia, you use the sword to make the case and to make the consequences of your judgment being reality and coming to this point. Yes, it is something, not just an intellectual exercise, but it is an exercise that has consequences. Binary code, you go to prison or you don't go, and everything else is a little bit difficult, that you say, okay, you go to prison during daytime, but at night you can go home. Don't laugh, this is a relevant decision, for instance, where politicians had been sentenced to some kind of this sentence, part-time imprisonment or something. Of course, Italy. I leave it here, and we can then come to other points at a later stage. Thanks, cheers.
Comme un enfant aux yeux de lumière qui voit passer au loin les oiseaux.
Comme l'oiseau bleu survolant la terre, voit comme le monde
est beau. Beau le bateau